Thank you, Mr. Chairman. Professor Harris, good morning. Welcome.
Thank you.
In a couple of sentences, how would you define judicial activism?
Senator, I think that can mean different things to different people. I would define judicial activism as a judge who allows his or her personal views to color decisions made as a judge, and perhaps also as a judge who goes beyond the facts of a case or further than necessary to decide an issue.
Mm-hmm. I agree with that definition, and I will confess I'm troubled by some of the public comments you've made, so I'd like to give you an opportunity to address them.
Thank you, Senator.
In 2009, at an American Constitution Society panel, you described yourself as, quote, a profoundly liberal person who sees the Constitution as, quote, a profoundly progressive document. And you went on to say, quote, I always feel unapologetically, left to my own devices, my own best reading of the Constitution, it's pretty close to where I am. Now, given the definition you've just given of judicial activism, those public comments raise some concern. How would you respond to those concerns?
Well, Senator, I would respond first, I think, by pointing to my entire professional career, or as a Supreme Court and appellate advocate at O'Melveny and Myers, running the Supreme Court Institute on an entirely nonpartisan basis. I have never let any personal views I have, political views I may have, affect the discharge of my professional responsibilities, and I would not do that if I were confirmed as a judge. With respect to those specific comments, if I can just give you a little bit of the context, they came when I was basically arguing against audience members who thought that the Constitution should be amended to address certain Supreme Court decisions that they found too conservative. And my point was that commitment to the Constitution actually ought to transcend that kind of political difference, and that was not an appropriate reason for amending the Constitution. I describe myself as liberal just as a matter of context, to suggest that even though I might share some of their political commitments, I did not believe the Constitution should be amended for that reason, and that I did believe commitment to the Constitution transcends politics.
Looking to those comments, is it a fair inference when you said that your best reading of the Constitution pretty much always conforms to your own personal political views, which you described as profoundly liberal? Do you agree with that statement?
Senator, only in the absolutely most broad sense in which I was using those terms in that comment. I do believe that the Constitution is committed to values that were very forward-thinking at the time, and this is what I meant by progressive. Values like democracy, rule of law, equality, individual liberty. I think that's a very non-controversial proposition, and that's all I was saying there.
As I understand it, you have been committed to liberal values your whole life, which I commend you for the consistency. My understanding is in college, with respect to President Reagan, you said, quote, the greatest American nightmare of our time would be a second term for Ronald Reagan. Is that, do you still have that view?
Senator, I do not, and I am happy to have the chance to address those columns. Those columns were written 30 years ago as a college student. They represent what were then my very earnestly held, though somewhat uninformed views. As I sit here before you, I cannot really accept them today. I'm proud of my youthful passion. I deeply regret my tone. I think if you talk to people I've worked with over the last 20 years, they will tell you that I pride myself on my open-mindedness, my respect for people with whom I disagree, and in knowing what it is I don't know. To the extent that my early columns do not reflect that, I regret that.
Well, I appreciate your comments clarifying that. Let me ask an additional question. Also in 2009, you criticized liberals for believing that the Warren Court's decisions were, quote, as liberal as it gets. and you responded saying, quote, "That's not right." And you went on to say, quote, "We've stunted the spectrum of legal thought in a way that removes the possibility that there could have been more progressive readings of the Fourth and Fifth Amendments." Now, as you know, the reaction to the Warren Court criminal procedure rulings that were widely perceived to be creating loopholes and allowing dangerous criminals back onto the street was fairly dramatic, and it is unusual for judicial nominees to have taken a position suggesting that the Warren Court was not nearly liberal enough and it should have been more liberal. Is that your view? I want to understand what your view is on that question.
Senator, that's not my view, and it's also really not what I said. And again, if I can just give you the context on that, I was responding on that panel to an argument that justices perceived as liberal, like Chief Justice Warren, had never, and I think the phrase had never felt the pain of reaching a constitutional decision that disagreed with liberal views. And the only point I was making was that several of Chief Justice Warren's criminal procedure decisions had not, in fact, adopted what was being presented as the liberal view. And I believe I talked about the Terry case. And that was the only point I was making, that sometimes people assume that because Chief Justice Warren wrote an opinion, it must have been terribly liberal. I was simply pointing out that in the criminal procedure context, Chief Justice Warren wrote opinions that did not adopt what was being advanced as the most pro-defendant or liberal position. It's just a descriptive point about certain criminal procedure decisions.
Well, thank you for being here and answering the questions. My time has expired.
Thank you, Senator Cruz.